Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Um, this morning, your case is set on what we call our arraignment docket. And what the arraignment is an opportunity for the court to tell you what you've been charged with, inform you what your rights are, and the options that you have regarding your case. Your case or cases that you have in this court, it's a misdemeanor case or they are misdemeanor cases. And that just basically means that they are not felony cases. Your felony cases are the cases that are held in our district court. They're what we call our most serious type cases. The misdemeanor cases are not as serious as the felony cases. They're normally referred to as petty offenses. However, they are serious. We handle Class A and Class B misdemeanors. There are 3 types of misdemeanors: Class A, Class B, and Class C. Your Class C misdemeanors are those cases that are handled normally in the justice court or the municipal court. The range of punishment for those type cases are fine only. You cannot be sentenced to county jail time. However, in Class B and Class A misdemeanors, your punishment can entail punishment in the county jail. If you have a Class A misdemeanor, the range of punishment is confinement in jail for a term not to exceed 1 year, a fine not to exceed $4,000, or both such fine and confinement. If it is a Class B misdemeanor, the range of punishment is confinement in jail for a term not to exceed 180 days, and a fine not to exceed $2,000, or you could be given both such fine or confinement. Now, you may be eligible for probation. There are 2 types of probation. One type of probation is called deferred adjudicated probation or unadjudicated probation. The other type of probation is called adjudicated probation. We commonly refer to it as regular probation. The difference between the 2 is as follows. With the adjudicated probation or the regular probation, it does result in a conviction on your record. However, there's something that is called judicial clemency, whereby the court can set aside that conviction. And the way that works, first, you have to successfully complete the probation. There cannot be any more time left on the probation, and you have to be discharged off of the probation. If those 3 things happen, then the court can allow you to come back in the court and to withdraw your plea. And if that happens, then the court can set aside your conviction. And if your conviction is set aside, basically you do not have a conviction in this case. However, if you commit if you are convicted of a subsequent crime, another crime later on, then the conviction can be revived, resurrected, or brought back up. It can be used against you. If you try to get a license with CPS, they could deny giving you a license, or if you have a license, they could suspend or revoke that license. Now, with the deferred adjudication probation, it does not result in a conviction on your record. And if you successfully complete the probation, the case will be dismissed. It would not result in a conviction in your record, and you may qualify for what we call a non-disclosure, which means we cannot disclose to the public that you were on deferred adjudication probation for this offense. However, if you violate the terms and conditions of your deferred adjudicated probation, and the state file a motion to revoke your probation, and after a hearing, if your probation is revoked, then you may get a conviction. And if you get a conviction, obviously the case is not going to be dismissed and you cannot qualify for a non-disclosure. You have a right to have an attorney. If you cannot afford to have an attorney will be appointed to represent you. So basically, as a defendant in a criminal case, you have three options. You may hire an attorney, or number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or three, you may represent yourself. If you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. The form that you was handed out earlier, the first page, I've just read that to you. At the bottom of that form, it states, Defendants Choices, mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll put your initials on the first line to the left. If your choice is, I have hired an attorney whose name is, then you'll put your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel, then you'll put your initials on the third line to the left. If your choice is, I have a court-appointed attorney whose name is, then you'll put your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right to an attorney and represent myself, then you'll put your initials on the fifth line to the left. Once you have finished putting your initials on one of those lines, then you will sign at the bottom on the line that says defendant, and you'll put today's date, February 23rd of 2021. Now, you also have a right to have a trial by jury. And basically what a trial by jury is where the mental health officer is sitting. That area is called the jury box. 6 citizens from Jefferson County will be selected to sit on your case. They'll listen to the evidence, decide whether or not you're guilty or innocent. And however, you also have a right to waive or give up your right to have a jury and have your case just come before the court or the judge. You also have a right to have witnesses to come to court. And witnesses, they can testify for you or against you. You have a right to ask some questions. We either call that direct examination or cross-examination. Now, you also have a right to waive or give up your right to have witnesses, which means you have a right not to have any witnesses to come in. You have a right not to call any witnesses if you desire not to do so. You can waive your right to have witnesses in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. If you desire to see that evidence, then the state can allow you to have access to that evidence. Or if you have an attorney, your attorney will have access to that evidence. Or you also have a right to waive or give up your right to see the state's evidence, or to waive your right to discovery. And you also, now, if you are not a U.S. citizen on a plea of guilty or nolo contendere, it may result in deportation, exclusion from admission, or denial of naturalization. If you are representing yourself, or if you have an attorney that's representing you, your attorney or yourself will have the opportunity to speak to the prosecutor to see if y'all can work out a settlement on your case. We call that a plea bargain agreement. If you are able to work out a plea bargain agreement, the court does not have to follow that plea bargain agreement. If I do not follow that plea bargain agreement, you have a right to withdraw, which means you have a right to take your plea back. If I do follow the plea bargain agreement, then, and if you decide to appeal your case within 30 days, what an appeal is, you would like to have a higher court than this court to look at your case. And if you decide to appeal your case, you have to get the court's permission if the court has followed the plea bargain agreement. Now, if the court gives you permission to appeal your case will go to the Ninth Court of Appeals, which is right above us. And they will review your case. They will decide to grant or deny your appeal. If they grant your appeal, then they can find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial. Or if they deny your appeal, you will have a right to appeal it to a higher court than them. That higher court is called the Texas Court of Criminal Appeals. It's located in Austin, Texas. It's the highest criminal court in the state of Texas. They will review, you would have to file what is called a pro se petition for discretionary review. Pro se means you would have to file it on your own without the assistance of an attorney. And you'll be filing a pro se petition to the Texas Court of Criminal Appeals, asking them to review your case to see whether or not your case, whether or not the court committed error by convicting you, or whether or not you was wrongfully convicted. They'll review your case, and with the brief that you filed, they'll review your brief. If they decide that your appeal should be granted, then obviously they can acquit you, find you not guilty, or they can send the case back down to this court, or to this court to give you a whole new trial, or they can deny your appeal. Once they deny your appeal, your case will, at that point, it'll be final. Okay. All right, thank you. Now, and so those are your appeal options. Now, for certain misdemeanor offenses, including those involving family violence, it will result in you being ineligible to purchase or possess a firearm for any purpose. Jefferson County District Attorney's Office has a program, and the program is called pretrial diversion. With that pretrial diversion program, it's normally for first-time offenders. It cannot be an offense involving unlawfully carrying a weapon or an offense of resisting arrest. And if with the pretrial diversion program, if you qualify for that program, and if you're placed in that program, your case will be dismissed. And you will, if you complete the program, as I said, your case will be dismissed, and you may qualify for what we call an expunction. Now, what an expunction is, it means that this case will be deleted, erased, or wiped off your criminal record. All right. Now, however, if you do not complete that program, they can bring the case back up, and they can pursue the charges against you. And obviously, you cannot get an expunction for that. Now, you have to get a lawyer to assist you with getting into that program. That's one of the requirements. If you are a veteran of any one of the branches of the United States military, the Jefferson County District Attorney's Office has a program that is called Veterans Court. It's part of the pretrial diversion program. Again, you get into that program, you complete the program, your case is dismissed, and you can qualify for an expunction. Now, this court, County Court at Law number 2, has a program. We call it our CSI program. CSI stands for Community Safety Initiative. It is the program that I started after being on the bench for about 2-3 months. And the program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, go to church. It addresses the issue of what we call recidivism. Recidivism is where people commit crimes over and over. In that program, we have a myriad of partnerships with various agencies in the local community. We have a partnership with Spindletop MHMR, our local mental health agency. They also have drug and counseling and education. Our partnership with them entails that we have, if a person have a mental health issue, it could be any one of the mental health issues that a person may have. Then we have individuals in court who will do a private interview in the conference room with the individuals. They will come up with a assessment and a treatment plan, either outpatient or inpatient. If a person has an issue with drugs or alcohol, through that partnership with Spindletop and with Ozor, our local drug and alcohol agencies, Spindletop will assist with the youth, anybody 21 years or younger, and then Ozor will assist with everyone else. You could be, for criminal purposes, 17 years on up. And what they'll do is do private interviews, do a screening, and develop a treatment plan, either outpatient or inpatient. Now, we also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE, and that stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program. Individuals who in the program are trained in the hotel industry or the shipping industry or the chemical industry, whichever one they choose. And once they are trained in those areas, the program CICE will help them to get employment in the area that they are trained in. Now, if individuals do not have a high school diploma and you would like to get your high school diploma, Lamar University as well as Spindletop has a GED program to help you. Now, the reason why I mentioned the program that we have here in County Court at Law number 2 is not because we're different, but basically we're trying to, I tell people this all the time. When you come to County Court at Law number 2, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before the court, and we're trying to make a difference in the community that we live in. Now, with the program, it produces productive people. And if we produce productive people for the most part do not commit crimes. And so therefore our recidivism rate, our people committing crimes over and over will go down because we're producing productive people. Now, the other thing is all of the programs that I just spoke about, all these programs do not cost you 1 cent because they are free. Only thing you have to do is say that you want to be a part of it. Now, earlier I mentioned that with a Class A or Class B misdemeanor, the range of punishment may entail a fine, jail time, or jail time and a fine. It also may entail probation, either deferred probation or regular probation. And the reason why I brought that up is because uh, everyone in here has been arrested on their case. And because you've been arrested, any time that you spend in jail, you can get credit on that jail time towards your punishment. For example, if the state is offering you 5 days in jail, you spent 5 days in jail, they may say, okay, we give you credit for time served, which means you don't have to serve any more time in jail. Or if you had to pay a fine, every day that you spent in jail, you get credit at $100 per day. So for example, if they offered you a fine and court cost of $500, you've already spent 5 days in jail, that's $500. So you won't have to pay the 5 days, the $500, because you'll be given credit for the time that you spent in jail, and that fine and court costs will be taxed and retired. Now, if you cannot pay the fine on the day that you're sentenced, we could either give you time to pay it out, or we could put you on a payment plan. Or if you can't pay the fine at all because of your financial situation, then we can convert your fine and court costs to community service. Every hour of community service you do, that's $12.50 that will go toward your fine and court costs. Now, the reason why I brought that up is because of all of the programs that I just spoke of, the mental health counseling, drug and alcohol counseling, GED program, job training, job placement program. If you're in any one of those programs, every hour that you spend in that program, it can be used as 1 hour of community service, and it'll be $12.50 towards your fine and court costs. So in essence, you're killing 3 birds with 1 stone. The fine and court costs, the community service, and then the program. You sitting in the class getting the GED, but while you're sitting in class, every hour you're there, you get 1 hour of community service, and $12.50 is going towards your fine and court costs. Okay, so that's the program that we have here. It's called the CSI program, and if you're interested in the program, just let us know, and we'll be happy to assist you in any way that we can to try to help you, address your needs, either your mental health needs or your alcohol and drug needs, as well as your needs for jobs or GED. Now, we have someone here. We have Deputy Hinton. He's a mental health officer with the Jefferson County Sheriff's Office. And he's going to talk to you about the mental health program that they have. Deputy Hinton.
Thank you, Your Honor. Good morning. This truly is a specialty court. Just like the judge said, he has partnered with the Sheriff's Office, who I work for, and also with Spindletop. We work collectively together to help people with mental health issues or substance use disorders. What we found is, as the judge has already said, is we found people who are going in and out of the jail system and out of the court system sometimes has underlying mental health issues or substance use disorders that contribute to their purpose of being here. So if we can address some of those issues, as the judge wants us to do, and advocate for y'all, then sometimes we can stop people, get them out of the jail, get them out of the court system, and work with you. So what we're going to be doing as the court proceeds, we're going to be, I'll be going around and speaking to every one of y'all and see if there's anything that we can address or help you with. Our goals and objectives is if there is mental health issues or substance use disorders that you're willing to take advantage of, again, it's a free service. We will help you and walk you through the system. Sometimes it's complicated, sometimes there's a lot of red tape. We can break those things down for you because we work there on site, on the campus at Spindletop itself. So we can help with that. Maybe you have family members that you would be interested in talking to us about, that we could help them as well. We're just here to help. That's what we want to do. The judge, he cares for people. It's not just a court. This is a professional setting to advocate for y'all. This is what we want to do. This is where his heart is, and this is where we want to help him as well. Does anyone have any questions? Good deal. Good deal. Thank y'all very much, and I'll be talking to y'all in just a few minutes.
Okay, thank you, Deputy Hinton.
Thank you all.
Now, as Deputy Hinton was speaking, I failed to mention that in this court, we don't just arrest the problem, we address the problem. And so this is a program that we have. If you're interested, just let us know, and we'll see what we can do to help you. We get it into one of the programs. Now, I've already went over the judge's explanation, and if you have any questions, we'll be happy to help you with that, with the paperwork. And we're gonna put you into, I guess we're gonna have the paperwork picked up. Once we picked up with the paperwork, then we'll put you into one of the 3 categories that we've talked about, okay? All right.